460 West 4th Street, which is right across the street from this proposed project. Mr. Cherno referenced an individual who's on the neighborhood council. That would be me. I have a letter from the Fair Political Practices Commission. Apparently he filed a complaint against me that basically vindicates the position that I acted in accordance with everything that's necessary. But you're correct, it's irrelevant. Really, this is a disguised zoning variance request, disguised as an elder care facility conversion request. You hit the nail right on the nose that there are 6 findings, and the most important is whether or not there is any unnecessary hardship to this applicant, not to their residents or the proposed residents, but to this applicant. The only evidence or any argument that this applicant has made is that it is financially difficult for them. And they need to just demonstrate dire financial hardship. The problem is that he's lived here, the applicant has lived in this building for at least 10 years, in the building, renting it as a rent-controlled unit for all this time, and suddenly he's introducing this out-of-scale, overly intensive use, trying to convert a roughly 3,000 square foot building into something that is 5 times bigger, totally out of scale. He's lived here for 10 years, apparently effectively using the property as zoned, as R2. So where's the hardship? Apparently he also has 6 other facilities that are doing just fine, just fine. There is no showing of any unnecessary hardship whatsoever. There is actually a case. I am an attorney, just for full disclosure. I have looked at the case law, and there is a case called Walnut Acres, and the Court of Appeals specifically held that unnecessary hardship cannot be in the form of some self-imposed hardship, like building a parking garage. This is something that they're volunteering. They don't have to build it if they don't want to. This is something that they are imposing on themselves, and that is not sufficient to warrant a variance in the zoning. He has used this property subject to the R2 zoning just like everybody else for 10 years, and there's nothing here that requires any change. He hasn't demonstrated any other arguments other than that argument. That's the only argument that he's made. He's also, I guess the only other argument that he could have made, which it seems, he references that there is some difficulty in maintaining 2 separate units and that you're gonna have to build 2 kitchens. That really goes back to the argument that he's gonna lose economy of scales. In other words, he's saying it's gonna be more efficient for him and cheaper for him to just build this as 1 unit so that he doesn't have to incur further costs himself. But case law again says that's not enough. That is not enough. And I don't know what other arguments he could possibly make. If you compare the properties, my property is no different. In fact, it's probably in worse of a position than this property is, because we share the same characteristics, except I have less square footage and I deal with probably even more issues that he does. This area has been burdened with pre-existing and ongoing traffic and parking issues, which I'm sure that many of these folks will be talking about today, so I won't burden you with that. But we've fought to preserve what the law already allows, to preserve the R2 use. We are next to a commercial zone, and we have been fighting to preserve the R2 use regulations. And as neighbors, we're entitled to expect that. In fact, the fact that this applicant has used this property as such for 10 years, I think acts as an estoppel. You know, he's basically used it in a certain way, and now he's suddenly deciding to turn about and introduce this